for amendment. Could I ask members to confirm that set of minutes, please? Thank you. Since the last meeting, some information papers have been issued. After the meeting on the 23rd of March, the clerk issued 5 information papers. These are listed in the agenda. Any questions? The next meeting and items for discussion. The next meeting will be held on the 27th of May, a Wednesday, at 8:30 a.m. This is not the usual Monday 10:45 slot, because that Monday is a public holiday, so we postponed the meeting for 2 days. The administration proposes 3 items for the next meeting. Number 1, future development of the electricity market in Hong Kong. Number 2, update on follow-up actions arising from the report of the Commission of Inquiry into the collision of vessels near Lamma Island on the 1st of October 2012. Number 3, proposed creation of a supernumerary directorate post for supporting the development of the maritime industry. This is quite a packed agenda. Any other proposals? You agree? Okay. I'd also like to tell members that on the 16th of June, there will be a special meeting. This is because Mr. Kenneth Chan, Mr. Dennis Kwok, and Dr. Fernando Zhang have separately written to the panel requesting public hearings be held on the future development of the electricity market. So we are going to have that public hearing on the 16th of June. I'd like to ask members if the regular meeting in May will allow us to listen to the views of the or introduction by the administration, and then we have the hearing afterwards. Do you support that kind of schedule? Okay, if you have no problem, the clerk will arrange for a public hearing to be held at 2:30 p.m. on the 16th of June. That means the panel will discuss the future development of the electricity market both in May and June. And we are going to invite the members of the EAP to attend those 2 meetings. You agree? Ms. Ann Chang, Chairman, I'd like to ask about that public hearing. Are we going to invite experts and professionals to come to state their views, or who are we going to invite, please? The convention is that we would issue the invitation on the internet, and people can respond and apply freely. And then we will draw up a list of participants for your reference, whether it be our members or political parties or anyone indeed. They can come forward and apply and respond to our ad on the internet. If there are no other questions, we'll go into item 4, guidelines and document prepared by the Competition Commission as required under the Competition Ordinance. I'd like to welcome the chairman of the Commission, Ms. Anna Wu, and her team for coming to the meeting today. The Commission will first of all brief the members on the guidelines and other documents prepared by the Commission, and also the Memorandum of Understanding that will be signed with the Communications Authority, the principles that are followed, and also the fees standards that are proposed by the Commission. May I please now hand over to Ms. Wu to give us that introduction, please? Thank you very much, Chairman. I would be as brief as possible in telling or updating members of the Commission and also the schedule we have in mind. We have Dr. Stanley Wang, who is the Chief Executive Officer, who will be introducing the papers to you. At the same time, Mr. Russell Butt will also be telling you about our publicity activities. And last but not least, I will also have to let you know that we have Mr. Sander Chuk and Ms. Elaine Hui, who are from the Communications Authority today. This is really a report to members and also to consult members on the revised version of the guidelines in the consultation paper. The drafting of the guidelines has been the subject of 3 rounds of consultation, and the final revised version was released at the end of March. In fact, the law has not come into action, but we have received complaints, petitions, and inquiries. Up to this moment, on our record, we have about 100 concerns and complaints. And then there are 300 to 400 other inquiries. We can see that the public expect us to implement the law as soon as possible. The Commission is prepared to kickstart the implementation any time after the middle of the year, but of course it depends on how things go. Right now, we are studying into initial issues, including building management and repair. The Commission really waits earnestly that the commencement notice can be tabled to LegCo before the end of June, and also by the 1st of December we can commence the law, so we can start our work comprehensively. Now, if the commencement notice can be taken forward, then there will be some leeway given to the business sector so that they can make use of the time to do final adjustments. As you know, the law has been endorsed, and it in fact has been some time since it was endorsed. And these have become the accepted standards in society, and everybody will have to act according to that piece of legislation. The Commission is also duty-bound to tackle any contraventions. As you understand, I'm sure you do understand, that we are asking for a culture change, and there will be doubts and questions that will be raised, because you are going to change from one mindset to another, and we need to do a lot of publicity and promotion. But in fact, the law is not hard to understand, and I mean the principles behind the law are not difficult to understand. It is very clear that we want to build a market with clear standards, and there should not be any abuse of market dominance, price rigging, etc. I think the business sector understands that very well. Fair competition will be good for both the business sector and consumers. From our figures, we can see that when there is anti-competition, prices will go up by about 10%. So if we can commence the law sooner, we can lower the instances of distortion. Now may I hand over to our CEO to let you know the MOUs.
Members of LegCo today. The revised guidelines that are before you are the culmination of a process which began in the spring of 2014 when the Commission launched its first public consultation about expectations about the competition ordinance and expectations about the forthcoming draft guidelines. Throughout the entire process from spring 2014, and I may add continuing today, we have engaged and are engaging through meetings and seminars with stakeholders and other interested parties about the application of the competition ordinance. The comments we have received from these public engagements have been taken into account in the process of drafting the guidelines. The initial guidelines, that is the draft guidelines, were released on 8th October 2014. The Commission received 64 submissions from a wide range of interested parties and stakeholders. All these submissions, as part of our process, are posted on our website. These submissions have been of great assistance to the Commission in identifying areas where amendments, clarification, and further guidance were warranted. The comments were taken into account in producing the version of the guidelines that are now before you today. The revised draft guidelines were released on the 30th of March 2014. There are two main changes from the previous versions. First, we clarified and refined our explanation of various topics. Second, we clarified some examples and provided further hypothetical examples in the revised draft guidelines. I should note that in most of the submissions that we received, we were complimented on our use of hypothetical examples, and we were encouraged to provide more of them in the revised set. Since releasing the revised draft guidelines on the 30th of March, we have received additional comments from 7 interested parties. We will take those and any other comments we receive into account in producing the final guidelines. Let me now turn over to the Memorandum of Understanding between the Commission and the Communications Authority. As members are aware, the Commission and the Communications Authority have concurrent jurisdiction in relation to the enforcement of the competition ordinance in the broadcasting and telecommunications sector. The ordinance requires the two bodies to have a Memorandum of Understanding for the purpose of coordinating the performance of our concurrent functions under the ordinance. Our paper today highlights the key principles and features agreed by both agencies to be included in the MOU. Colleagues from the Office of the Communications Authority, the Secretariat of the Communications Authority are here with us today. Now to the fees regulation. The government has asked the Commission to make recommendation for the fees to be prescribed under the competition ordinance in respect of applications to confirm the applicability of exemptions and exclusions in the ordinance. Some proposed fees and factors considered by the Commission in arriving at those amounts are outlined in our paper. The Commission has published these proposals on its website and is consulting with chambers and small business organizations. The Commission will recommend to the government it be given the discretion to waive or reduce the fees. We propose to publish guidance on how the discretion will be exercised. Our paper outlines some of the possible criteria that may inform this decision. In conclusion, the guidelines we are bringing before LegCo today are only a small part of the guidance and assistance the Commission will be offering to businesses in Hong Kong to prepare for the implementation of the ordinance. The Commission will continue to reach out to the public and businesses through a range of different activities. My colleague, Mr. Russell Butt, will now give you more details on these initiatives. Russell?
各位議員，就競爭條例相關
With regard to publicity and promotion on the competition ordinance, I'd now like to detail to you what we did in the past and also what we are going to do in the next 12 months. In 2014, the Commission actively contacted the business sector to introduce to them the competition so that they can get prepared for the implementation of the ordinance. Until March this year, to the various chambers of commerce, small businesses and professional bodies, we have already conducted 130 seminars and briefings. We have also conducted 5 seminars just for SMEs. The response was extremely enthusiastic. To increase the awareness of the public about fair competition, we also have produced APIs which can be broadcast on radio and television. We have also released some education filmlets.
Now, in the end of 2014, the Commission also published a pamphlet or brochure called the Competition Ordinance and SMEs to assist SMEs in understanding their rights and obligations under the Competition Ordinance. In the coming 12 months, in terms of publicity and education, we'll focus on 3 fronts. We'll continue to prepare different educational materials. We have brochures for different sectors. We also have tools for to assist the sectors in making their own assessment for the smooth implementation of the ordinance, and also to enhance the public's awareness on competition-related matters and the competition ordinance. We will roll out a number of publicity initiatives, including roving exhibition, APIs on radios and television, and we would like to emphasize that we are producing a drama series with 10 episodes to publicize the importance of the competition ordinance, and we are going to launch the drama series in the middle of this year. And as for our way forward, we'll continue to liaise with stakeholders and different sectors, and through holding seminars, we will continue to get in touch with the SMEs and trade associations. We hope that by the publicity effort in these 3 areas, we will raise the awareness on the provisions of the competition ordinance so that we're fully prepared for the implementation. Thank you for your presentation. Let me read out the names of members who would like to ask questions. Mr. Dennis Kwok, Mr. Tan Ka Pio, Mr. Felix Chung, Mr. Wong Kwok Hing, Dr. Kenneth Leung, Ronnie Tong, Frankie Yik, and Yu Si Wing. Any other members? Or I'll draw a line here. Dr. Fernando Zhang. All right, 4 minutes each. Let's start with Mr. Dennis Kwok. Thank you, Chairman.
Consultation process, when the Commission put out the draft guidelines for consultation, a lot of law firms, my professional colleagues in the legal field, have filed submissions, and there are 2 particular issues that they are very concerned about. One is the market share threshold. I understand that the Commission took the view that it is not necessary, or it cannot be considered necessary that a market share threshold be imposed on by way of guidelines. And the reason seems to be because you see that different fields of economic activities should be considered separately. But I want to understand more about the logic in deciding on the market share threshold issue. The second one, as you can see, also raised in the American Chamber of Commerce paper, the resale price maintenance issue is also quite contentious, and I would like to hear the Commission's response on this issue. So 2 questions.
Yes, we'll take the question.
The market share thresholds, there are 2 issues here. One is the fact that market share, remember, we're trying to find out whether there's substantial market power. That is where the issue comes up. And in looking at market share threshold, that is only one of the factors. The ease of entry is another important factor. So from a pure a doctrinal point of view, if you will, market share threshold does not give you an indication of the existence or non-existence of substantial market power. The second point there is that we have been reminded many, many times over again in our consultation that Hong Kong markets are different from markets overseas. So therefore, we have to study the markets, which we have yet to do, before we can come to the conclusion whether a threshold of 25% is appropriate or 40% is appropriate. I know many of the submissions said, well, in the EU they did 40 or 50. I say, until we've studied the market, we cannot come to those things. And so that's to answer that question.
So in short, you're saying that after you've done the study of the economic structure in Hong Kong, there may be a possibility that a market share threshold will be introduced for particular sectors later on, but not now.
Certainly not now, but we will consider it. Obviously, studying it, studying one market, we're in the business of dealing with enforcement fundamentally. And so in much of the market thresholds that you will see in the experienced jurisdiction comes from many years of examining that market.
Okay.
Let me take on the issue from AmCham, which only reflects a lot of comments. In our first draft guidelines, we were criticized for being hard enough or not hard enough. And so we came back and looked at it. First of all, the Act speaks very, very clearly that any agreement as to price is a serious anti-competitive conduct. That's certainly what the statutes say. Obviously, we say, how are we going to interpret that? We say, well, in most areas, one need not be concerned as being an object infringement that is inherently anti-competitive. And the ones that will cause concern is if resale price maintenance is instigated by retailers who say to the supplier, please impose the same price on everyone. We say that's an indirect of cartels. Everything else, we have to look at the circumstances. For example, quite often in a franchise arrangement, the franchisor will say to the franchisees, we want you to have this type of menu, this type of clothing for the staff, this type of look and feel, and we want the price to be of this certain range. And we say when you look at that in that proper context, it may not be wrong to do that. It may not be anti-competitive. So what we're saying is that we cannot give you the hard and fast rules.
Yeah.
Mr. Tang Ka-piu, thank you, Chairman. I thank Chairman of the Competition Commission, San Wu, for meeting with us, the labor sector, on the class negotiation rights over labor rights. And I'm happy to see that this will not be regulated by the Competition Commission as a result of our negotiation with the Commission. However, for the self-employed person, things are not very clear because the Travel Industry Council will not be recommended that tips be given to tour guides and that such a schedule of fees would be abolished. And yet the tour guides are unsure how much they will be paid, and they are on a self-employed basis. And if they then form an association to discuss, for example, the tour group escorts, how much a day they should charge for, say, a Guangdong tour, well, then this is not clear because, first of all, they are self-employed. Now, second issue is about fuel prices or oil prices. We don't think the Environment Bureau has done enough to convince us that the prices are now appropriate. Now, for example, for the diesel fuel, the several companies charge the same price, 9.51 per litre. So is it a result of competition or is it a result of price rigging? Because no matter where drivers go, the price is just the same in Hong Kong. So 9.12, the same price for all companies. Two questions. Yeah, would Mr. Wong take the questions?
So with respect to self-employed individuals, under the law, they will be seen as undertakings if they engage in economic activity. But we also recognize the reality, and that was indicated in our revised guidelines, that if you're self-employed, but you're basically like a employed individual, then you may be treated as such. It will have to be based on looking at the specifics of it. And we think there is proper international precedents that allow us to go in that direction. With respect to fuel prices, we know this is a concern in Hong Kong and frankly, everywhere else in the world. But I think we are only at the early stages. We have said publicly we're going to look at that market even before commencement, and we have just started that process. As to the concern about all the prices that's posted in the service station being the same, obviously this is the phenomenon. If you were driving down the street and you had one that said 9.4 a litre and another one says 9.3 a litre, but they're on the same side of the street, if the person was continuing to hold 9.5, will they get any business? The answer is probably not. So that itself is not, because today consumers are buying gas really on price and not what was at one time quite popular to say, my gasoline is better than yours because they have additives that the other one doesn't have. But all I can say now is when we're looking at it, if there's something that we find there's a potential contravention, we will not hesitate to investigate it.
However, for oil prices, the fare hikes go very quickly, and the Consumer Council has made this point very clearly. Why is it that for motor spirits the prices are different, but not the case for diesel? Well, there is a response in the community that although they have not really put their heads together in terms of price setting, in fact, in the retailing prices, they are just the same. And this is also our concern. And we also hope that the Competition Commission can perhaps address this issue and allay the public's concerns as raised by Mr. Tankapio. Well, Chairman, perhaps at the policy level, let me supplement. On oil prices, we have begun a preliminary study. We understand that this is an issue of your concern. The situation has remained so for many years. And I understand that this is also a worldwide phenomenon. So different competition authorities in different jurisdictions are all looking at this problem. And in some cases, there have been investigations and also prosecutions. I want to explain clearly, however, that this is in the minority. As for policies, we're looking at two areas. First of all, whether public information is adequate enough, and we are interested in finding out whether there is enough transparency. And in various Consumer Council reports, they have suggested whether some sort of commission or committee on fuel prices could be set up, and we support this idea. We believe in such a coordinated manner the fuel prices could be dealt with more properly. Next, Mr. Felix Chung. Thank you, Chairman. Now that the competition ordinance has been enacted, we understand that traditional business practices may be changed, and trade associations setting prices may now amount to price rigging. And now we have guidelines, and I think they just serve as guidelines. Well, I have some concerns. The guidelines, on reading through it, seem clear, but for SMEs, they may not really have a good understanding of the guidelines. Well, they may follow the guidelines, and yet since the guidelines are not binding, then the court may make a determination that it is nevertheless a contravention. So if an SME follows the guidelines and yet in the end it's found to be anti-competitive, then will the rules be relaxed? And for oil companies, larger companies, well, we often discuss the issue of joint bidding. I wonder if the commencement notice can be issued as soon as possible to address these concerns. Mr. Wong.
SMEs, I think people would need to appreciate that guidelines are technical. And we have supplemented the guidelines, or in fact, we have converted the guidelines into some simple do's and don'ts for SMEs. We have done that through the brochures that we've already released. We'll be releasing one on trade associations, and we have already engaged in, with SMEs and their associations and their chambers about the application. With respect to the point that you raised, Mr. Chung, about what happened if they follow us and they go to the tribunal. First of all, it will probably never happen because we are the only ones who can take an undertaking to the tribunal. And so if they follow what we do, then they will never get into the tribunal and face that possible unpleasant scenario. Obviously, in a different case, the tribunal gives a clear interpretation of the ordinance. We will have to reflect that, and we will have to revise our guidelines if the tribunal disagrees with us. So let me repeat. If a SME or any other business follows our guidelines, they will never end up in the tribunal. because only we, the Commission, can start a proceeding in the tribunal, unless it's a follow-on action. But that only comes if there's been a determination that the party that is the target of the follow-on action has contravened the ordinance.
有冇跟進？
唔係。
Any follow-up? I'd like to thank Dr. Wong for his very clear explanation. But I also mentioned the commencement notice. Is it that once it is commenced, first of all, you will tackle the oil companies and which bid with the same tender price? Are you going to take action right after that? I can take that question. Right now, we are doing some initial studies so that after the law comes into effect, if in terms of building, repair, and oil prices, if we need to conduct formal investigation, then at least we know the boundary of our work. This study has started, and the commencement notice date and the period. I said that if there could be a longer period, there may be an advantage because we know, for example, that the commencement date will be so and so, and if there is some interim period, then people can make adjustments, and we are going to use that interim period to do publicity and education. Mr. Wong Kwok Heng. Thank you, Chairman. I'd like to take the opportunity to thank Ms. Anna Wu and the Commission for accepting the views of the trade unions to confirm that employees are not business entities. When trade unions negotiate with employers in class action, then that would be a kind of formal and regular negotiation. Because we are not business entities, so we will not contravene the competition ordinance. I thank the Commission for accepting our view. Now I have a question for the Commission. Maybe someone can answer that question. This is about Linkread. We all know that it is a listed company, but there are two aspects about Linkread that run counter to consumer rights and interests. First of all, the increase of car park fees. Two, in Linkread managed shopping malls, there are always hefty rent increases. I hope you will look at these. First of all, the increase in car park fees. As you can see, in recent years, car park customers have said time and again that Linkread is increasing the fees unreasonably. They have been staging motorcade, etc. We don't see the same happen in private car parks, at least not that often. This goes to show that since Linkread has a number of car parks under it, and in fact, therefore, there could be some fee rigging in reality, and consumers cannot have a choice because Linkread simply has too many car parks in its hands. I'd like you to look into the issue. Number two, Linkread manages and controls a number of shopping arcades. They can raise rents if the malls are under its direct control. And in fact, there is another phenomenon recently, and that is Linkread has contracted out the entire shopping mall to an operator. So the entire mall is managed by another contractor. And these contractors may hike rentals by a wide margin, and they are charging fees of every name. But tenants have no choice. Can you leave some time for them to answer you? They have no time to answer you. So I'd like you to look into these issues. So small operators who have no choice and consumers who have no choice will be helped. Chairman, maybe I can answer very briefly. You mentioned some issues. One, consumers' rights. 2, fair competition, and 3, on the policy level, when the government sells land or grants land, what can be done. The issues are very complicated, and I can only say to Mr. Wong that we can look into these issues later on to see where we can provide some information. I thank Ms. Wu for your very positive response. We would be very happy to collect information for the benefit of the Competition Commission because people's livelihood is very much impacted upon and is very unfair. Mr. Kenneth Chan.
And that the abuse of market power is not a conduct which the ordinance would aim to alleviate in the short run. So am I correct to say that whenever we conduct a merger and acquisition transaction in Hong Kong involving, well, if one of the parties is a Hong Kong company or Hong Kong group, there is no need under the current regime to ask for a pre-clearance from the Commission? That's my first question. The second question is a more general question. Under the current regime, would the Commission be proposing any advance clearing or advance ruling system at all for those issues covered by the purview of the ordinance? Thank you.
Anna?
主席，如果可以嘅話
Ms. Wu, if you would allow, I'd like to ask the Telecommunications Authority to let you know how we handle telecommunications matters, because the merger rule would only apply to telecommunications.
The communication, as you understand, right?
明白嚇，因為
Yes, I do understand. Because with regard to the code on merger, this only applies to the telecommunications. And also you mentioned advance ruling. I can defer to Dr. Wong to answer you in a moment. Can I now ask Mr. Chuck to take the question? Chairman, members, under the competition ordinance, the merger rule would only apply to business entities which are licensees with unified carrier license under the telecommunications ordinance. In other words, they must be telecommunications companies. Mr. Leung, you are correct. Under the competition ordinance, when two business entities involved in merger and acquisition, they do not have to give advance notice to the CA or the CC. They do not need any approval in advance.
advance ruling.
With respect to advance ruling, the Act does not provide for a formal procedure. But I can assure you that we have already engaged with many stakeholders who've asked us questions. And in some instances, stakeholders understand the implications of the ordinance, have changed their behavior. I expect that that will continue going forward, and certainly in the early months and years of the application of the ordinance.
Okay. Well, one follow-up, new question I would like to know. Under the current regime, the activities, I'm talking about the economic or activities of statutory bodies are exempt. But in fact, some of the statutory bodies like the Trade and Development Council, in fact, is engaging in commercial activities like the conduct of exhibitions and all that. Would you have any plan in the future to review the ordinance so that the commercial activities of these statutory bodies would come under the purview of the ordinance in future?
主席，
Chairman, let me answer this question. Statutory bodies would be reviewed as promised by the government later. I hope there will be a review later, and also they will seek our views. Secondly, statutory bodies are exempted, but then there is also a cap to the exemptions. I'd like to ask Ms. Rose Cap to explain to you what will happen in the situation you painted.
Brief in your answer, please.
Sure. I just wanted to point out two issues with the statutory body exemptions. One is that other entities that engage in conduct with the statutory body would still be subject to the ordinance. So if there's contractual arrangements, they're still subject. And the ordinance also does give the Commission power to investigate the activities of statutory bodies, just not to take action against them.
Thank you, Rose. 湯家華議員。
Mr. Ronnie Tong, in the past 10 years or so, I have been working very hard to promote the competition ordinance. I'm very happy to see that finally it is going to be a reality. But when the ordinance is triggered, there will be 3 bodies involved in the competition policy. First of all, the compact. Secondly, the telecommunications or CA, and then the competition commission. The 3 bodies, especially the CA, and they will be promoting and implementing the ordinance. But in the past, not all 3 have done the same and put in the same effort. For example, compact, I haven't seen any particular achievements that it has secured. And also the CA, it seems it is not doing a lot about competition in the telecommunications market. We know ATV is not no longer competitive, and it is going to wind up. This is what we all know. So I'd like to ask the chairman and CEO of the commission, after the law will be kicked into action, what will you do so that these 3 bodies will use more or less the same standards and work to the same standards to promote competition, so that you will promote the same message in promoting competition in Hong Kong? How can you make sure that within the government itself we can see more determination? Chairman. Thank you. First, I'd like to thank Mr. Tong for his few questions. I'd like to say that for the compact and CA, well, actually for ourselves and the CA, we have the MOU, so that we have the same standards and objectives when we do our work, and so that there will not be any gaps between us, because somebody may lodge a complaint and they may think that the other party is handling it. But there is going to be an internal arrangement so that there will not be any gaps in our cooperation. This is what the MOU will take care of, so we can work to the same objectives. I will also ask Mr. Chuk to add his side of the story. As for the policy level, we have a function of providing information and making recommendations to the government. Of course, we can of course submit our work reports to the government. You mentioned the compact. It is a consultative body. It will still have a role to play in the future. And maybe Mr. Tong, you can see whether the compact can do more after we have the ordinance. Let me say something else. If you look at overseas countries, there are departments of the government that are exempted from the competition ordinance, but then they may have a statement, a declaration on competition. They will say that the law may not govern them, but they nevertheless will firmly stand by the line of promoting competition. However, I haven't seen any positive moves amongst government departments so that the quality of our governance will be improved. Well, I accept the view, because we must have a firm stance, including government policies. We will be very happy to make recommendations which will be published. We have a few reports already, and there will be other reports, and those recommendations will be made in the open. But then I hope the government will also implement this internally within government. Mr. Albert Chan, thank you. We have waited long and hard for the ordinance, and after the guidelines are released, We hope we can put an end to cartels or monopolies. I think many members are also concerned about this issue, and that is price rigging among oil companies. I don't know whether after you have the guidelines, the situation will indeed improve.
Secondly, we understand that the government's conduct will not be regulated by the Competition Commission. Now, recently, the court has ruled on the case of Hong Kong TV that there is something wrong with the government's conduct. Now, I don't know if the Competition Commission will do anything about the government's conduct in the Hong Kong TV incident. That really goes against competitiveness in the TV industry. A number of areas are important, as I can see. That is market dominance, etc. I mentioned a number of points. That is market dominance in the TV industry. This has gone on for a long time. We believe this will continue to be the case. And I wonder if the Competition Commission can do anything about it, or whether the Commission can intervene because of the government's political intervention. And also, please answer me the question on fuel prices. Well, Chairman, let me briefly give an answer, and then I'll defer to my colleague. Now, on fuel prices, I thank Mr. Chan for his suggestion. Now, first we should look at whether there is any contravention. If so, we'll definitely act on it. And we also look at the policy issue. And yes, the government's conduct is not regulated by the Commission, but it doesn't mean that we do not have a stance. The Commission definitely has a stance, and when time is right, we will state our stance and discuss with the government. But the focus is, if there is already internally a competition policy in the government, they should be more proactive in promoting that policy. If they don't have such a policy, they should start working on one. And I'll defer to Mr. Chuk to answer your question on the TV industry. Now, as far as competition is concerned, the Communications Authority will act in accordance with the competition provisions in the relevant ordinances to deal with any competitive conduct. And when the Competition Commission, the ordinance takes effect, we will also rely on these new provisions to deal with market dominance, abuse, etc. Now, what about the government's abuse? Because the court's ruling is very clear. It reprimands the government's conduct in certain ways, but now the government is exempted. Now, I am not in a position to disclose the matters relating to licensing here. So there's nothing you can do. Of course, I understand that the government's conduct is exempted. But what about the decision made by the government to interfere with the private market? It is against the decision of the CA. I think you should pay attention to this, and you should look into this. You should act on it and not to allow the government to have all the say. Chairman, may I try to take this question? Now, first of all, the government is exempted. However, does it mean that we cannot give a response to the government's policies? At the level of the Competition Commission and the CA, we can state our stance. However, you're talking about a court case as a result of a process that have been gone through by the Communications Authority. So it may have to do with some administrative issue. It may not be directly related to competition at this stage. I totally understand your question. However, now the judge is saying that the government is wrong and that the administrative procedure is wrong. And it doesn't really relate to the decisions made by the CA now. It doesn't affect the decisions or the policy of the CA. So that's my elucidation. Mr. Frankie Yick. Chairman, I'd like to follow up on the issue in the logistics sector. We met with you some time ago, along with members of the sector, on block exemption. Vessel sharing agreement or VDA, I see in your paper that we can rely on Section 15 and also apply for exemption under certain circumstances. However, the sector's question is this. Now, Dr. Kenneth Leung talked about an advance ruling, and he asked whether Hong Kong will follow the international practice. And as you understand, we need a longer period of time for vessel arrangements. If they don't know whether exemption will be granted in Hong Kong, then they will probably deploy their vessel fleets elsewhere. And this will greatly affect Hong Kong's competitiveness, and they may decide to unload the goods in Shenzhen instead. So you need to be clear. You should tell them before the implementation what they should do, whether they should apply or not. Maybe I'll defer to Dr. Wong to answer this question.
Until the ordinance is commenced, there are many things we cannot do that we're required to do under the block exemption. For example, to post the application, to consult third parties. This is a process that takes time. We have obviously started, we've received obviously letters, and it's been public on that regard. We said that at this stage we're trying to get ready in a bunch of areas. Well, obviously, if we consider that application, there's the implication that everybody else will say, you haven't started for business yet, but can you give us an advance ruling? We have to weigh all that, and we said to the shipping liners, in particular, said we will consider the issue again in July, once we have a clear picture as to when commencement takes place. But I also want to emphasize, until commencement start, there are many, many things we're required to do for a block exemption that cannot be done.
Okay, 主席，
All right, Chairman, I want to make the question more clearly. Now, I understand Dr. Wong's answer. However, this doesn't apply to our situation, because you say that only after the ordinance takes effect would you review the applications. However, if you don't tell the ship liners what to do, before the ordinance takes effect, they would decide to go, because with uncertainties they won't operate here. This is the problem facing us. I have a question to you, Chairman, on fuel prices, and you say that this will be dealt with later this year. I understand. However, for the ocean liners, if you don't tell them the clear picture, they will go elsewhere today, and this will affect Hong Kong. Ms. Wu? Now, before making any decision on any sector, we will first get in touch with them. We hope that through getting in touch with them, we can have an initial understanding. Now, as I understand, a block exemption order may not necessarily be obtained from the Commission for exemptions to apply, as long as certain criteria are met. And I look forward to discussing with the sector again, and I understand your question. In major industries, I understand that they understand thoroughly the competition ordinance. Can I pursue one question, Chairman? Does it mean that I can have another meeting with the Commission along with our sector? Because if you deal with this issue after the ordinance takes effect, that would be a great problem in our container terminals. I understand, well, in the middle of the year, if things are smooth, first of all, the ordinance will take effect. And like Dr. Wong said just now, it would be better for us to reconsider this issue after July. Mr. Yu Si-wing. Thank you, Chairman. Now, after publicity effort made by the Competition Commission, the tourism industry also looked into the matter. Different members have different views. And on tips for tour guides, now we scrapped the maximum already. And this policy change caused the labor sector to respond as well. So now on price setting, different associations have different views, and they are considering whether some, for example, proposed tour fees would amount to price rigging, and they are seeking legal advice. Now, responding to Mem Chair's remarks, there is a notification period before the law really takes effect. As I understand, different members of the sector have different understanding. And if the Commission believes that there is already a contravention, I want to know whether there is any flexibility, whether there will be any prosecution instigated as a result of the contravention within this period. Now, let me take this question. Well, after the commencement of the notification period, before the law takes effect, this will be the best time to take preventive measures. And we'll be happy to discuss with anyone with questions. Now, that doesn't amount to a contravention within the notification period, but after the law takes effect, then of course this will amount to a contravention. Well, say if the date is set at the 1st of October, then after the 1st of October, we will have the power to launch investigation, prosecution, etc. to address the issue. But before that, it is not yet a contravention, and you should make use of the time to address the ambiguities. I don't know whether I've answered Mr. Yu's question. So does it mean that starting from the commencement date of the ordinance, no more negotiation will be possible? But before that, negotiations are possible? Or does it mean that within the notification period, we can continue to discuss, and then even after the ordinance takes effect, we can still have some flexibility? Well, if there is a commencement date set for the ordinance, then starting from the commencement date, when the ordinance takes effect, we definitely take enforcement action. However, before the commencement date, because in the legislative process we're required to have a notification period, it's just a matter of the length of the period. And we are making the period longer so as to facilitate our work in addressing doubts in the sectors. It has nothing to do with flexibility. It has to do with the commencement date. Before the commencement date, we cannot take enforcement action. However, we can work with the business sector and see what issues we can deal with first. So that means we can say have an association discussing with you when the commencement date should be. Now, we welcome any questions on commencement date for different sectors and whether amendments are necessary. Dr. Fernando Cheung. Thank you, Chairman. Of course, we want the competition ordinance to be implemented as soon as possible. The bill has been passed. The bill was passed 2 years ago, and we still need to wait for its formal implementation. Now, the 6 draft guidelines are highly technical. I think ordinary members of the public will find it hard to understand. I hope the Competition Commission will deploy more resources on education publicity. In particular, complaints from the public. There should be sufficient manpower to deal with these complaints and to explain to the public. Now, we also welcome enforcement action by the Commission to deal with the large companies, the supermarket chains, the oil companies, etc. Of course, we understand that there may be overlapping areas, and we also see this MOU. Now, just now, Dr. Wong answered the question on fuel prices, and I am somewhat surprised. I have been living in the U.S. for 15 years.
And I have driven a car both in Hong Kong and in the U.S. In the U.S., the oil companies exhibited different prices. So I was surprised by Dr. Wang saying that in Hong Kong, of course, the price will be the same because consumers will be watching the price before they choose a station. However, I was in the U.S. for over 10 years, and the stations would exhibit different prices, and it depends on the brand and the company, and they fix their own price. Why is that so? As consumers, we have seen that oil companies have been quick to raise prices but slow in reducing prices. And then there is another miracle. Because they are totally coordinated when they raise or reduce prices. We know that they have some kind of tacit understanding among them. How did they come to such a situation? Is there a mechanism for them to talk, or is it purely market force? And the few oil companies already enjoy considerable market dominance, and it's very difficult for new entrants to go into the market. Well, they don't have to have anything in writing, but as long as there is this tacit understanding, consumers will not be able to fight back. So I don't understand why Dr. Wang is saying that this is a natural phenomenon. I think it's very unnatural. And it's not the same as what I have seen in another part of the world. If you say this is a phenomenon that's okay and you don't have to deal with it, then I would be quite worried. Can the Commission respond? Dr. Wang. Chairman, can I please first answer? I support Dr. Zheng's views, and we accept it. As for the oil market, since it's such an important issue, we are already starting a study. Maybe Dr. Wang can answer you on the details.
Yes, I think with respect to the study, I mean, remember our responsibility under the competition ordinance is to look for contraventions. And we've, as our chairperson has already indicated, we've started to study the market. But members should be aware that our powers to get information for the purpose of studying the market are very limited. We cannot compel a company to turn over information. Other jurisdictions have laws that allows the competition authority to compel information. Obviously, if whatever we find or what we get from the public of complaints of allegation of price rigging, then if we think there's sufficient information, then we can use our enforcement powers to get more information, compel that information, get a search warrant if it's appropriate. As to the phenomenon, I should correct myself about the two prices. If you have two service stations next to each other, all I'm saying that the prices may be the same because the second service station will get no business. Now, I appreciate that in other parts of the world, there are all sorts of complicated issues, and some of it may be what the headquarters will say. You can lower your price if you deal with another major brand, but if it's not a major brand and it's a sort of a wild brand, you're not allowed to authorize this. But this is a complexity that we will have to study.
I think your time is up. I would have to ask the last speaker to speak on this issue. Mr. Chen Kam Lam. Chairman, we support the competition ordinance. So the business environment in Hong Kong will continue to be fair, open, and free. But this will be the first time we have implemented such an ordinance, and enterprises may not know very clearly what it says. So may I put forward this request? When you really make those guidelines, please do a lot of publicity. This may not be a problem for the big corporations because they may have their own compliance department or compliance personnel. So it will be easier for the large entities. And I'm worried about the SMEs. They may not always understand the law. And in fact, for a long period in the past, there may be fees that have been charged for decades in an industry, like the tips or service fees for tourist guides, and also the service charges in the catering industry. These may be called conventional charges. And they have been with us for so long a period, and it has become like a habit. And in those industries, these have formed a kind of a relationship between employers and employees. And they may have to undergo a lot of changes when there is this law. When the businesses have to make changes, it may be difficult for them. So when you consider market situations, you have to seek an understanding into the different industries, and please do not just do it in a broad brush approach, especially at the initial period of the commencement of the ordinance. I hope you will let people know the competence of the Commission, and I don't want you to overdo it or underdo it when you implement the law. I don't want you to want to show people your teeth when the ordinance comes into operation, and the industries would all be so frightened, not knowing when they will be your target. Because to cope with your investigation, they may have to spend a lot of time and energy to work with you. So during the initial period, I hope the Commission will really understand the industries, and they need time to adapt to the new environment. Also, I hope you will do a lot of publicity to help people understand what can be done and what cannot be done, and what could be done but can no longer be done. Please give time for them to adjust and adapt, or else it would be a big problem if they contravene the law. Mr. Chen Kam Lam, would you like them to answer you? No, Chairman, I am stating the view of the DAB on this matter. I just hope that they understand our view. If they are also listening to the industries, so there will be more communication, I think that will be good. Chairman, I will be very brief. I'd like to thank Mr. Chan for your view. I know you are well-intentioned, and we accept your view. We will be issuing simple guidelines for the benefit of SMEs, and we are going to contact them and do a lot of publicity. Indeed, we did that before, and we will again do it. As for implementation and enforcement, I'd like to mention that if it is a minor contravention, there will just be a warning, and also there will be small amount exemptions for SMEs. Thank you. Just now, Mr. Chen Kam Lam raised his concern. Now, if SMEs are complained against, and of course they would put up a defense, and after going through the procedures, they are found to be innocent, will there be a mechanism for the Commission to compensate the SMEs like what the courts do? Well, you can rest assured, members, when we write the guidelines, we of course will also be binding ourselves, and if indeed we have a mistake, the tribunal will make an independent judgment and can comment on our mistake, and we will be asked to pay costs, and that could be a big amount. So you can rest assured, during the legislative drafting period, we have already considered how ourselves could be bound by the ordinance, and people can in fact apply for judicial review of our decision. Chairman, I hope the Commission will enforce the law in such a way that SMEs will not be very much frightened by you. because I'm afraid the SMEs may not fully understand your work. I take your point. We will be very careful.
Or I'll try to ask as many as possible. I've been told by competition law experts that the way the guidelines are being implemented means our competition law will be far straighter than the approach in the US and potentially even straighter than the European Union. An example is that suggestion that exclusive clauses will be presumed anti-competitive in some circumstances where businesses have market power, without even looking at the effect of the clause. There are good commercial reasons for businesses agreeing exclusively provision in the agreement, and other jurisdictions look very closely at whether the clause is an abuse of market power before they might prohibit it. Hong Kong has always had a strong faith in market, and it was expected that the law would be proportionate and appropriately tailored in Hong Kong to take account of our brief belief in market. Why then in such a strict approach being taken in the guidelines?
主席，多謝解你嗰個問題。
Chairman, thank you. I understand your question perfectly, and I will ask Dr. Wong to answer you. But allow me to say, no matter what, our law, when compared to the US and the European Union, can be said not to be strict at all, especially in the area of penalties. Plus, in the EU, the European Commission can decide what penalties are meted out, but this is not done by us in Hong Kong. And may I ask Dr. Wong to answer you with your example?
The competition ordinance distinguishes between two types of way to contravene the law. Under the first conduct rule, dealing with anti-competitive agreements, and second conduct rule concerning abuse of substantial market power. A choice was made. It says that you can contravene by object or by effect. And when you have those choices, and this option is taken from the European treaties, the European competition law. So we have tried to explain what we mean by object. If, for example, you engage in price fixing and nothing else, there is no doubt that this will almost certainly be an object infringement, object contravention, without having to look at the fact. And that is the interpretation of the European statute, which I think makes sense as to why we have the choice. In the United States, is a different types of norms. So that is the reason. We have tried to explain very clearly as possible why we think that certain types of exclusivity is inherently anti-competitive. Of course, we can have that view, and if a party who's uninvested can come and try to convince us that's not the case. It's not like just because we said it is so that we're not open for discussion. I can assure the members of this House that our focus is on compliance with the law. We don't have enough resources. Nobody will ever have enough resources to take people to the tribunal. We're going to try to convince people. That is why we have done all this publicity up to now, and we'll continue to engage with parties. And even after the commencement date, once we come to a view that somebody's engaging in conduct that contravenes the ordinance, we'll talk to them. And they will know, if we end up going to the tribunal, exactly what our position is. And if we can resolve without going to it, we will do so.
So, in fact, we don't always have to do more than the UK and the US. And
vertical agreement are excluded from the equivalent of the first conduct rule, and that there is a block exemption for such agreement in the European Union. I understand a number of submissions in the last consultation highlighted that such an exemption is necessary to give more certainty to businesses in Hong Kong. Why has Hong Kong not adopted such approach?
Well, first of all, the Act exclude vertical agreements. An explicit choice was made by, LegCo not to exclude vertical agreements. So until we end up to the tribunal, we have to give faith to that. And what we have done is being sufficiently flexible. We say certain types of vertical agreements could lead to a problem. As I've already indicated with respect to a question from Mr. Dennis Kwok about resale price maintenance, if it's an agreement to basically if a retailer says to the supplier, please impose the same price on everyone, we say that is almost like indirect price fixing. That is one of the very few examples where we say inherently anti-competitive. We will look at all of the arrangements. And I remind the members of LegCo again that we're asked to look at the specifics of Hong Kong. The European Union's vertical block exemption comes from decades of experience and enforcement. And we cannot go there yet until we have studied the market. And secondly, we have no guidance yet from the Competition Tribunal, which is the independent body making decision. In the European Union, it's the European Commission itself that not only investigates, but also makes a finding and also imposes the punishment. We don't have that power here, and if I may add, I think that's a good idea. Somebody independently decides.
Okay, thank you. Well, I don't have time to answer all the questions, but Anna, you have something to add?
Right, I welcome any further discussion with you. I think that any piece of legislation should offer sufficient protection to members of the public as well as SMEs and the business sector. And however, if this brings too much burden to them, we also need to strike a balance. So Anna, I'll be discussing with you again, and I will also submit written questions for you to answer. Thank you. So I think that ends the Q&A session for today, and I thank Anna and your team for coming here. We've taken a lot of your time, a number of hours, because you need to take transport to come here, and if we have further comments, I'll forward those comments to you. Thank you, Chairman. Thank you.
係啦，咁跟住咧就係下一個議題，就係
Next item, auto fuels retail prices and domestic LPG prices. Well, let's first invite the government officials in.
今日參加我哋呢個會議嘅咧就係有
We have with us today from the government Ms. Christine Law, Undersecretary for the Environment. Also, Mr. Vincent Liu, Deputy Secretary for the Environment, and also Mr. Martin Ma, Senior Treasury Accountant of the Environment Bureau. So, Undersecretary, over to you. Please walk us through the paper. All right, I don't think I will go into the details. I think a number of members would like to ask questions, and I just saw from the TV screen that you were discussing with the Competition Commission. I think this may be somewhat relevant to the topic that we're discussing today. So if you've read through our paper and the LegCo Secretariat's background brief, you can have detailed information about the background. I wonder if members are going to ask questions on these two areas. First, on fuels prices, how are the prices set in Hong Kong? And secondly, what is the government's role in terms of monitoring the price setting process? So these are basically the two questions. I would like to ask my colleague to make a very brief presentation, and then we will take questions. I think this presentation may help address some doubts. So who would do this presentation, Vincent or Martin? Thank you, Chairman. Now let me focus on two areas. First, on auto fuels retail prices and also domestic LPG gas prices. I think you're concerned about the price setting and transparency. First, on auto fuels retail prices. Now, they are, as a matter of established practice, set by oil companies based on their operational costs and the crude oil prices. Now, we have been following on whether the oil companies have make adjustments to their pump prices based on changes in the international crude oil prices. If possible, they should keep it more in line with the changes of the international crude oil prices so as not to affect people's livelihood. We noticed in recent years that the international crude oil prices have dropped significantly, and yet the downward adjustment of retail prices have not kept up with the substantial drop. And this is because the public's impression is that they are packing the two together, and the international oil prices have dropped by 50%. But this is not really an appropriate comparison, because the price factor comprises three. That is, the MOPS prices fluctuate day to day, and the oil companies do not adjust their auto fuels price daily. And there is also fuel tax on the retail price, and $6.06 per liter for petrol, and tax-free for diesel, and operating costs. So definitely, when international oil prices drop, they will drop more significantly than retail prices, and also and vice versa in the case of upward adjustment. And thirdly, well, the actual selling prices of auto fuels are effectively lower than the listed pump prices because of the various kinds of discounts and promotions to customers and drivers. Usually, oil companies are offering discounts of up to $1 to $2 per liter, and for unleaded petrol, we see recently that the discount could be as much as $2.5 to $4 per liter, as you can see in the slide. Yesterday, we see that the instant discount per liter is 2.2 for diesel. I want to point out that many would rely on the oil prices announced in financial news, that is the crude oil or Brent oil price, to assess the retail prices in Hong Kong. But this is not appropriate, because auto fuels in Hong Kong are refined oil products. They are not crude oil products. So the better comparison is to compare it with the means of Platt Singapore or the Singapore free on board prices. In fact, in early July last year to March, the important price has experienced a 50% drop, and the oil companies, as a result of the drop, adjusted downward the pump prices of unleaded petrol, with a maximum accumulated reduction of about $3.2 per liter, and that's about 50% of the imported price of the oil products in July last year at $6.34 per liter. So in fact, the price adjustment is for retail refined oil products is almost the same as the international crude oil prices adjustment, and we've tried to increase transparency. In fact, in our Environment Bureau's website, we have published the imported prices of refined oil products, auto fuels, and also the trend of Singapore FOB prices. And recently, the figures related to the auto fuels pump prices are also available online. There is a link, and we've also commissioned the Consumer Council to come up with, to prepare an auto fuel price calculator. And on a weekly basis, the Consumer Council would, through the auto fuel price calculator, announce the retail prices of local auto fuels, as well as cash and non-cash discounts offered by oil companies, so that on this website you can find the cheapest price and the relevant discounts and benefits. As for domestic LPG price adjustment, we should draw reference from the imported price of Saudi Arabia, which may be very different from the international crude oil prices. And now we have a local LPG importer, which will adjust the price on a 3-month basis, and they will also forecast the price difference in the coming 3 months based on the Saudi Arabia monthly exporting contract price. And according to our observation, other LPG companies basically follow the same price adjustment mechanism. And between July last and January this year, the imported price of LPG dropped from $7.29 per kilogram to $5.64 per kilogram. And the domestic piped LPG has also reduced by about 20% from $38 per cubic meter to $31 per cubic meter. That's more or less the end of my presentation. Now we have Mr. Albert Chan, Felix Zhong, Tan Ka Piu, Frankie Yik, Li Cheyan, and Dr. Fernando Zhao, and Mr. Sham Kam Lam. I'll draw a line here. Mr. Paul Chair? Oh, okay. 4 minutes each. Mr. Albert Chan. Well, Chairman, we understand totally. When it comes to price adjustment, the crude oil prices would definitely be different from the retail prices, and the per barrel price, I will not be as naive as to suggest that the rise or fall by 50% should be strictly followed. However, in the past few months, you can see that the international oil prices have dropped very significantly, from $100 per barrel to about $40 to $50 per barrel. However, for retail prices, they were only adjusted very mildly, and the difference is really unreasonable. And the because we think that the rise, the increase in oil prices have been very quickly in the past. And please perhaps explain to us after the meeting about the time needed for such a price hike for the wholesale price and also for the retail price. Because in terms of the time required for the price drop, I think is unreasonable. And as far as the government is concerned, I don't see anything being done to monitor the price changes, because this is unreasonable. Price hikes happen very quickly, and price drop happen very slowly and very moderately. So the government seems to be favoring oil companies, and consumers as a result see their interests being affected or undermined. So please explain why there is an impression among the public or users that price hikes happen quickly and price drop happens very slowly and moderately. Under Secretary. I think we agree with the former part of what Mr. Albert Chan said, that is on government's role in monitoring the prices, and if we look at the data, we can see the price fluctuations over the past few years, and that may answer Mr. Albert Chan's question. As for the latter part of the question, I think we will prepare some information and reply to the panel later. And I'd like Vincent to explain in greater detail about our work. The principle is that we have no intention whatsoever to allow oil companies to make a few more bucks for a few more days, because this is price rigging. This is, among the oil companies, they engage in price rigging, and this is fact. Whether price rigging is involved, I think just now the Competition Commission already said that they have begun investigation, and they will be asking the government for information, and will definitely work with them. Well, just now, Chair of the Competition Commission already briefed us on their work, and I think we can discuss these two issues separately. Let's talk about the government's monitoring. Now, Mr. Albert Chan has been very candid. He said that although the government claims to be monitoring the prices, this still happens, and this is there are calculations that back up this theory.
跌嗰陣時就得益，升嗰陣時就唔使，都未加就即係俾多咗錢咧。咁都希望即係政府可以向呢方面做多啲唔得，或者阿 Vincent 可唔可以簡單啲回應？
好簡單嚇。我諗即係加快減慢度咧，其實要睇翻個零售價入邊嗰個油價嗰個成本係有冇調整到。咁正如頭先我所解釋咧，我哋睇到咧嗰個油價成本嗰個調整幅度係同呢個國際油價咧個走勢係相類似嘅。咁頭先陳議員要求話，即係想睇翻過去幾年嗰個嘅趨勢，其實我哋係有個走勢圖咧係喺個。
Mr. Chen asked for information for the next 3 years. Actually, we can supply that kind of information to the panel for information. Mr. Felix Chung. Thank you, Chairman. I think we all agree that indeed oil prices go up quickly and come down slowly. Especially in the past year or so, international oil prices have dropped from $100 to $40-odd. Yes, they have reduced prices, but only by 10 cents and then another 10 cents. And then when it goes up to $50-odd, the increase is by 30 cents every time. I drive a car, so I'm very sensitive to the oil prices, and I understand the ins and outs of such increases. Recently, the increase is by 20 cents every time. So it's 100% that prices go up quickly and come down slowly. If you really want to get information from them, you will see this quite clearly from the information. Of course, oil prices will say our cost is not just for importing oil. We also have to tender for the site of the station. Well, the paper says that they are going to allow 3 to 5 pieces of land for auction or tendering so that new entrants can acquire a critical mass so as to achieve economy of scale. But as you know, tenders mean the bid will go to the highest bidder. They have to pay high prices to the government for the site. And apart from importing oil, if the tender price is high, of course it will be transferred to the cost, and oil prices or pump prices can never be too low. Do you really want to go for a tendering system for people to operate oil stations? Can you change this mode of operation so operators do not have to pay so much for the land so that they can sell oil at a cheaper pump price? Under Secretary. Chairman, it's difficult for me to answer this question. Now, what criteria should we use to allocate land? If we don't go for the highest bidder, then whatever mechanism we have, I'm sure LegCo will still comment on it. So it's difficult. But I think what Ms. Chung is driving at is how we can have a mechanism whereby we can have lower pump prices. But can this be achieved through changing the tendering system? Chairman, I think Mr. Frankie Yick can let the Undersecretary know a new system that we are proposing so she can go back and consider it. Secondly, the duty is over $6. Will you consider lowering it? This is within the jurisdiction of the FST Bureau. Chairman, the Undersecretary cannot just say this is a policy of another bureau and refuse to answer the question. I was saying whether she could take this back. She could say, I will relate your message, and you cannot just say it belongs to another bureau and it's none of my business. Well, it's not up to me to say the Undersecretary should answer the question, because this is really outside the jurisdiction of her bureau. Maybe the Undersecretary can reflect this view to other officials. Mr. Tang Ka-Piu. Thank you, Chairman. These oil companies are international conglomerates. They will want to make the biggest profit. They are international enterprises. And of course, they would like to increase prices as quickly as possible and by the widest margin as possible. The Consumer Council has already proved it, and it's up to the government to have the will to control it. Well, it's all right if they want to go for the biggest profits, but then we suspect them to be rigging prices so that they have a cartel among them. The Competition Commission is starting to work on this, but I don't think the government should wait for the Commission to finish its work before you bring in changes. Isn't there something you can do as well? The Environment Bureau is here. The Deputy Secretary, you have a team of a dozen people. You also have to look after the 2 electricity companies. Do you have enough people? Do you have enough capacity to exert pressure? Oil stations is one thing. Domestic LPG is another. I don't even have time to go into it. Do you have enough capacity to do it? As the Competition Commission was saying, the government should consider setting up a statutory body or even just a committee to look into competition or otherwise in the energy field. Will you accept that proposal? That's the first question. Just now, you say there are fixed costs, but I can raise further concerns. As I was quoting from the Consumer Council, the diesel of the 5 large enterprises are selling at the same price, and that is $1.92 per liter. But then according to your information, the rental for stations can be very different, from $18,000 to $740,000 in 10 years. That is a 40-time increase. So the cost has increased by 40 times. However, the pump price is all across the board, $9.12. If it is not a cartel, what is? Mr. Liu? When members look at pump prices, you have to consider the discounts provided by the oil companies, and the discounts or concessions differ. Sometimes it's 90 cents or $1. Some people offer over $2. So the prices do differ. And also, some fleets or large customers also enjoy extra discounts. Therefore, the prices are different. As for the rental value of stations, it depends on the location, the size of the stations. So you can't just say one station is so inexpensive in rent, the other one so expensive. You have to consider different factors. Exactly. This is what I'm saying. The rentals vary, but how come the diesel price is always the same? And the Consumer Council did not mention the pump price, but actually the price after discount. Why is it that when the rentals are different, why is the diesel pump price the same? And Undersecretary, please answer the question on the statutory body. I cannot answer that question. The most high-ranking people in government have to come to a decision about that. And about oil prices, I remember when I was in the Legislative Council, we discussed the issue, and there was a special committee set up to look into it. It was chaired by Mr. Ronald Aculli, and he said that it was not so easy to decide whether there is a cartel. But now this time around, we have a dedicated Competition Commission. I hope it will allow us to better understand the situation and how we can do something if indeed there has to be something done. Mr. Frankie Yick. Thank you, Chairman. Let me not talk about whether the reductions are the same. As Mr. Albert Chan was saying, we are not that stupid. But the Consumer Council has already released a report confirming that the prices go up quickly. It takes 4 days on average to increase prices, but it takes 8 days to reduce prices. I'm not sure why your press release does not accept the report. I think what the Consumer Council did was very reasonable. They looked at the difference between the import price and the pump price. Well, that we can discuss again, but listening to you, it seems you are not going to do anything. And we will certainly complain to the Competition Commission once the law is effected. In fact, it is very easy. You just look at the store, the sale level, and you will see how much they have in stock and how it will, in what period it will be depleted. So we know how long we should wait for increases or decreases. As for the stations, it is not fair to NT residents. As we saw and as Mr. Tenkapil was saying, the rentals are different. Now, of course, the rent for the stations would be much cheaper in the new territories, but they are paying the same thing for the fuel. So they are cross-subsidizing the urban users. And then there is another unfairness. If I have a big fleet, I can apply for a lot of discount, and the diesel can be reduced by $6 per liter. But if you just have your own vehicle, you have to pay $11.12 or $9.12. So there is unfair competition on another level, and the Secretary should look into it. As for land prices, I have always thought that is a problem because you charge doubly the tax or duty. You charge $6.06 for each liter of fuel, but you also charge for the land. In fact, oil station should be a kind of infrastructure. You should not go for the largest return from the land you rent out. And I propose to the Secretary or the Bureau, you should fix the price of the land, be it 3,000 or 30,000 per square meter, and everybody should pay the same thing for the land, but the one proposing the lowest pump price would get the bid. So there is incentive for people to reduce their operating cost. Right now, there is no incentive whatsoever because every cost can be transferred to the consumers. You are telling me this cannot be done, that cannot be done, but it's a matter of will. I have sat down and I have talked to the Consumer Council, and it says that my view can be considered. I don't know when I can find the time to sit down with the Bureau and have a discussion. And the Secretary, let me explain how we view the Consumer Council report. There are some principles in the Consumer Council which we don't agree with. Say, for example, they use the percentage of international oil change and compare it with the percentage change in local pump price. As to the phenomenon members talked about, we could see that early last year when international prices began a downward trend, and it took a week when there was an increase, when the prices are heightened. And in fact, we saw that the oil companies only took 3 days to reduce prices. And in fact, we have seen 2 price reductions within 3 days once. But as to why the Consumer Council used that kind of comparison, it would be up to the CC to explain. And members said that a big fleet can have a bigger discount. You say it is unfair. But then members seem to be contradicting themselves because you also say if the price is the same across the board, it is a kind of unfair competition. So I prefer not to answer when there is a contradiction. Mr. Lee Cheuk-yen, but before you ask questions, I'd like to extend the meeting by 15 minutes because 3 other members would like to ask questions. Mr. Lee Cheuk-yen, it seems the government is speaking on behalf and defending the oil companies. It seems they are trying to overthrow the observation of the Consumer Council. But the Consumer Council has not just compared prices once. They have done their report over a long period of time. You mentioned the diesel price, $9.12, and you mentioned discounts, saying that there are discounts and so there is no cartel. I think it doesn't help at all because the discounts are just a sleight of the hand. Members of the public don't always remember what discounts there are. Of course, you can go for the auto-fill price calculator of the Consumer Council. But if you ask members of the public to always think about which company to patronize when they need a refill and how the discounts are on a daily basis, well, it can say that the government is not doing any monitoring at all. So my first question is it that you are handing over this issue to the Competition Commission so that when it receives a complaint, it can start an investigation and you just sit with arms folded?
Now, the other question is on domestic LPG and it affects people's livelihood. According to your explanation, between July and March, the price have been reduced by 20%. However, according to the electrical briefs table, between May 2014 and January 2015, in fact, it's a reduction from $9 to $5.64. So the drop was about 40%. However, we understand as far as retail prices are concerned, the drop was only slightly more than 10%. So did you monitor the price change? It seems that you're only reporting on the price change, but in fact the government could monitor more actively because this is a livelihood issue and people cook every day, and if you don't monitor the price changes, then the companies can do whatever they want. And I am only using your set of figures to calculate against the Saudi Arabia monthly exporting contract price. However, I don't see the retail prices being reduced by 40%. Undersecretary, your first question. The information that we're trying to give you is not to find out if there is cartel among oil companies. We welcome an in-depth discussion by the Competition Commission. So let's separate the two issues. I can ask my colleagues to explain further our monitoring work. Yes, it seems that the price adjustment comes slower. And perhaps you have read the Consumer Council's report. Perhaps you don't trust us. You may think that the Consumer Council's report is entirely correct, but we find that there are errors in the report, and we welcome an exchange with the Consumer Council. Now, we're not saying that the oil companies have not done anything wrong, and we welcome the CA in following up on this. So, any monitoring on LPG prices, Vincent? We have been monitoring LPG prices. We mentioned just now that the price adjustments would be done once every 3 months with reference to the Saudi Arabia monthly exporting contract price, and that there will be a forecast on the price in the coming 3 months, and suitable adjustments would be made. So in setting the price for the next 3 months, we will be given some figures. That is, we will look at the actual contract price for the past 3 months, and we will then decide whether it is reasonable or what the actual price should be. And we also draw reference from the CNSD's figures to see if their forecast is reasonable or not. And we also make adjustments, so we follow up very closely on the prices. Can you give us a table? What happened last year? For example, starting from January 2014. Yes, no problem. Dr. Fernando Zhang. Chairman, I think transparency is very important. I assume that you're relying on the same set of data, but the result is very different. be it the Liberal Party, FTU members, or other members, we all have the same impression that prices increase very quickly but drops very slowly. As drivers, we are very sensitive about price adjustments, and that's also the case for LPG prices. However, I heard from the government just now that actually from your data, you're suggesting that prices go down quickly and go up very slowly, and I think that we're living in two entirely different spheres. I'm sorry, that's what we said. Well, maybe the government can respond later. Just now I heard from the PS that it takes a whole week for the price to go up, whereas the price may drop in just 3 days. And occasionally prices fall twice in just 3 days. So those words were very clear. You could listen to the playback. And why don't we just disclose all the data? The government mentioned other considerations, duty, etc. And why don't you give us the figures about government duty so that the public would understand better? Don't just tell us that you're monitoring closely when you keep all the information, because the public is having a totally different impression. That's point number one. Point number two, I live in South Horizons, Chairman. We don't have a choice. We have piped LPG. Domestic piped LPG, same as other housing estates, and price adjustment would definitely affect us. So the first question is how we can allow consumers to have more choices. That may not be the Environment Bureau's purview, but anyway, that's a question for the government. Secondly, there is a price adjustment mechanism for one LPG company but not the other two. Does the government have the intention of regulating this price adjustment mechanism so that the whole mechanism can be disclosed? Second question about whether there is a price adjustment mechanism for all three LPG companies. I'll defer to my colleague, but I want to clarify about your first question. My colleague is not trying to change your impression by suggesting that prices go up slowly and drop quickly. He was just citing some examples about some situations. We're not hiding anything. And I just want to make it clear that indeed there are such circumstances. I don't want to twist the scenario and trying to explain that the oil companies' operations are entirely justified. Now the problem is the Consumer Council, based on the data, suggests that the prices go up quickly and drops slowly. But on the same set of data, you suggest otherwise. So our stance is very clear. And then the government disagrees and cites some contrary examples. Vincent. Now let me talk about the LPG price adjustment mechanism. So far, only one LPG company uses the mechanism of making price adjustments on a 3-month level. We see other local LPG suppliers using the same kind of adjustment mechanism. In fact, after the LPG company makes price adjustment, the two other companies will follow suit, and that reflects. The price adjustments reflect the movement of international LPG prices. So there is no monitoring at all. Mr. Chen Kam Lam. I think the public's impression is very often different from the government's version. As Mr. Lau said just now, a company has announced its or make public its formula, and for price adjustment, and the other two LPG suppliers would follow suit, and this gives an impression that they are engaging in collusive pricing. So I think apart from announcing the price adjustment mechanism by one company, we should ask the other two companies to disclose the details as well, so as to avoid this impression that they are denying any cartel. So I think the government may exert its influence to enhance transparency, because the situation now is not very desirable. Now, of course, international oil prices fluctuate, and we source our supply from the same source. The procurement prices may not be too different among companies. And the retail prices, however, may be different because of different operating costs of these companies. Still, we have this impression that the retail prices are very similar, and we therefore have this impression of cartel. I think the government should exert a greater influence to encourage oil companies to disclose their price adjustment mechanism. And apart from that, they should also disclose the information about costs, so as to avoid these suggestions. The government may be saying that they are monitoring closely, but still the public has this impression. My question is whether the government would further discuss with these LPG suppliers. The Competition Commission is working on it, and they may need to face up to the new mode of market operation and see if transparency can be enhanced. And the Secretary, we're not against that. For example, you can see that we're requesting more and more information from the two power companies. We ask for a greater degree of disclosure, and we can also discuss this with the oil companies. And I think they're watching the webcast, and I think they understand the government's stance and the members' stance. And this is what we're going to do, and I think this will be very helpful in taking things forward. And I mentioned in the past that the committee chaired by Mr. Akoli did not come up with anything concrete because we couldn't get more information. Well, the government can ask for information, but without statutory requirements, it may be quite difficult to actually get information. However, we've come to a stage in our community that there is now greater awareness of competition matters, and I think this is what the public feels. And I think after the Commission's report is published, there may be a lot of observations and recommendations for the government, and we can then take things forward. But right now we can go back and see, in terms of transparency for these oil companies, what we can get, what information we can get as soon as possible. Chairman, I hope that through the Competition Commission in the future, the industry's transparency can be enhanced. So that there won't be another impression in the minds of the public. I think the Undersecretary's position is very clear today. There is a public impression or perception that oil prices go up quickly and drop slowly. Of course, it's difficult to compare retail prices with crude oil prices and future commodities. These are all issues. But recently, we see that indeed prices have dropped, have been dropping more quickly. Perhaps that's coming from the effort of the government. But as members suggest, in the long term, you should strive at enhancing transparency and make operations smooth. And at the same time, you need to strike a balance between that and the business sector. It is possible for them to disclose all the details to you. So between fairness and transparency, you need to strike this reasonable balance. So you need to strike a balance. And now we have this competition commission, and the law will take effect, and this will things will improve.
Okay, this is the end of the discussion today. Thank you, three officials, for coming. AOB, under AOB, anything? If there is nothing AOB under AOB, the meeting next time will be held on the 27th of May at 8:30, not the usual Monday 10:45 slot. Meeting is adjourned. Thank you.